Yes, Mr. Deep. I cannot hear you.
Am I audible now?
Yes, now you're audible.
Before I go into the other details, I will try to make it as short as possible. I would first of all like to refer to Annexure 11, page 43 of the petition.
Okay, page 43.
I know it might be a repetition, my lord, but this is very important. Page 43 of the petition.
Yes.
Annexure 11. Decision of the Council of Ministers
Yes.
obtained by circulation. Proposal for obtaining opinion of the Council of Ministers for imposition of governor's rule within the Chakma Autonomous District Council. As per provisions contained in Rule 15 of the Government of Mizoram, Transaction of Business Rules 2014, as amended from time to time, the above proposal of District Council and Minority Affairs Department was circulated amongst the members of the Council of Ministers for opinion. The Council of Ministers is of the opinion that the new claimant for formation of a new council be afforded an opportunity by the government. However, my lord, there is a however. The Council of Ministers is willing to accept. This is very important, my lord. The Council of Ministers is willing to accept any decision made by the Honorable Governor, as it is a discretionary power. The Council of Ministers is mentioning that it is a discretionary power of the Governor to take action as he considers necessary. Now this, my lord, I will most humbly submit before your lordship that this has to be read along with 20 BB. Let us come to 20 BB.
Yes.
Come to 20 BB. Exercise of discretionary powers of the governor in discharge of his function.
Yes.
Now, my lord, I don't want to go into the details. Everything is there. Your lordship has just now gone through it. What I would like to refer to is of this schedule, shall. My lord has got it. Just 2 lines.
Yes.
2 lines from of this schedule, shall, after consulting the Council of Ministers, and if he thinks it necessary, the district council or the regional council concerned take such action as he considers necessary in his discretion. Now, my lord, there is not a whisper in the Constitution or in the 6th schedule or in 20 BB that the governor has to abide by the advice of the Council of Ministers. It is a discretionary power. The aspect which relates to the advice of the Council of Ministers and thereafter the action to be taken, whether it is as per the Council of Ministers' decision, is absent. It says, take such action as he considers necessary in his discretion. That means, which has to be read, that not according to the advice of the Council of Ministers. So as far as 20 BB is concerned, it is absolutely the discretion of the governor.
Yes.
Now the question whether the action of the governor is similar to that of Article 356, which was just raised by my lord. Now, my lord, 356 and 6th schedule should not be read together. 6th schedule is a different aspect which relates to Autonomous District Council and the discretionary power of the governor. When it relates to 16.2 or 20 BB. But 356, my lord, in case of 356, the President of India is advised by the Council of Ministers, and the President has to act as per the advice of the Council of Ministers.
Okay.
So there is a lot of difference, huge difference, when it relates to 20 BB, read with 16.2 and 356. We should not mix these two aspects.
Yes.
Absolutely a separate issue altogether. Now, my lord, the action taken on behalf of the governor, if your lordship can kindly come to my affidavit, paragraph 4, page 4, second paragraph. Paragraph 4, page
Yes.
4, second paragraph, my lord. That
Of
the
your
constant
counter affidavit, isn't it?
counter affidavit, my lord.
Counter affidavit, yes.
Paragraph 4, page 4, paragraph 2.
Yes.
That the constant political instability is found extremely detrimental for the Chakma Autonomous District Council, as also the other Autonomous District Council, and is certainly not what is intended by the 6th schedule of the Constitution, which envisions the effective administration of the tribal areas for the interest of the people, which is certainly not what is intended in the 6th schedule of the Constitution, which means it is certainly not as per the guidelines and the provisions mentioned in the Constitution in the interest of the people. So that was the reason that if there is a political instability, how can the Autonomous District Council serve the people's interest? There has to be a stable government. Until and unless there is a stable government, the interest of the people cannot be served. Now, my lord, I have just now pointed 20 BB, which says it is a discretionary power of the governor. The Council of Ministers, the decision by which the Council of Ministers has left it to the governor, of course, with the specific mention that they should be given an option to prove their majority. Now, whether the governor should have considered that aspect of allowing them to prove their majority as per the advice of the Council of Ministers, which is apparently mentioned, I have just now pointed. Now, whether this particular aspect being not considered by the governor is a violation of the fundamental rights of the petitioner, that needs to be considered by your lordship.
But ultimately, Mr. Deb, ultimately, the majority, that has to be seen, ultimately that's a step that has to be taken by the governor. Whether the, whichever political party, whether they have majority or not, that is the ultimate step which has to be taken anyways, as per the, what
I
was
agree.
observed by the Council of Ministers, isn't it?
I agree, my lord.
Maybe if it,
And that
even
is
if
why-
it was not done immediately.
And that is why my humble submission that the Council of Ministers has advised the governor twofolds. It's a twofold advice. One, that let them be given an opportunity to prove their majority in the House, whether they really have a majority or not, and whether they can lead the CADC and provide a
Yes.
permanent autonomous
Which
district
is
council
the ultimate step that is required to be taken anyways.
and whether and the second option which has been given by the council of ministers is, as per the discretion of the governor, he can take any decision, which is there very much there in 20 pp. If it is read with 20 pp, the discretion of the governor is very much there, irrespective of the advice given by the council of ministers.
Yes, okay.
Now, whether the petitioner needs to be given an option to prove his majority in the House as per the advice of the Council of Ministers, or the governor is absolutely correct in exercising his discretionary power under 16(2) read with 20 bb, that is a matter to be considered by your lordship.
Now, what are the facts that led to the to the governor to conclude that there is political instability?
My lord, there is a political.
What are the thing?
There was a change in the autonomous district council since 2023 regularly. This was happening, and there was a change in the leadership, change in the political allegiance, and one after another this was going on. If my lord can kindly come to paragraph 4.
Beginning of paragraph 4. Okay, this is why the governor concluded that there is political instability, isn't it?
Paragraph 11.
Okay.
I would rather submit, my lord, that paragraph 4 from the very beginning. From the very beginning. So this was basically the reason
Okay. Yes. Okay.
why the governor came to a conclusion that there was a regular political instability and his discretionary powers should be exercised under 16(2) read with 20 pp. And that is why he referred the matter to the Council of Ministers for their advice, which is very much there in the Constitution, in the 6th schedule, in 20 pp, that he has to take the advice of the Council of Ministers. Now, whether he has to act on the advice of the Council of Ministers or not, that part, the Constitution is silent on that part. But the advice of the Council of Ministers, as we read just now, there are two advice. One, to allow them to prove their majority, and second, they left it to the governor to apply his discretionary power.
Yes. Okay. I
That's
got your
okay.
point.
Well, I think we can dispose of from Learned AG's submission, because he fairly submitted that.
Have you completed? Is that it? Anything else?
Let me. I have not yet completed. Now, my learned friend was referring to that fundamental right, Article 14 has been violated. I don't agree that fundamental right has been violated. The governor is very much entitled. Conclude, I would say, the governor is very much entitled. He is very much authorized by the Constitution to exercise his discretionary power. It cannot be read with 356. Here the governor enjoys a discretionary powers which he has applied under the provisions of 16(2) read with 20 pp.
Okay.
And that is what he did. Now, whether it was correctly done or not, whether he should have acted on the advice of the Council of Ministers or not, that needs to be decided by your lordship. That's all there.
Okay.
Although the Constitution is silent by now.
Yes.
That's all.
That's all. Yes.
My Lord, as a secretary to the CADC,
CADC.
we don't have much. We don't have much to say, but other than the facts that has already been laid before this honorable court, but my only submission is that out of the 20 seats in the district council, the ZPM party has hold the Majority of 17 seats,
Ah.
yes, my lord, as of now.
So you're adopting the submissions made by the
Yes, my
learned
lord.
AG?
Yes, my lord.
AG.
Yes, my lord.
Okay.
But just 2 points only. Because I think even landed AG also, that he submitted that the opportunity should be given to prove their majority.
That is the advice of the
No, I have
Council of
not said that.
Ministers. Council
That
of
is-
Ministers
I have not
advice.
said that.
Huh.
I'm
Yeah.
sorry. I don't agree. I don't agree with my learned friend. I have not.
No,
I have not-
so I'm
What I have
saying,
said- what I
you
have
have
said-
submitted is what the advice of the Council of Ministers, a suggestion,
Exactly.
huh?
Exactly.
Not what the AG said, huh?
Yes, so opportunity will be given. So that is that I would like to counter, and then again, and that admitted there had been 2 times changes, but I don't admit that there would be another change in the government. So that is I want to make it clear that. So it is admitted.
How can you predict that?
No,
Okay,
my
I
lord, we
think-
cannot go on a prediction. So even governor also cannot pass dissolution on prediction. That is also on the oral advice of
Okay,
minister.
fine. Okay, I've heard your submissions, I think.
And also, my lord,
What?
the last point is that just to reiterate what the landed government advocate general submission is that his submission is that the governor has discretionary power in view of 20 BP, and I have read that in Milai judgment and then
Yes.
para 28 and in
That's why
Nabanda
he's
VM.
countering what you have said.
Yeah,
No,
that
so you
is
don't
that
have to
The
repeat.
government has to act on the advice of the councils of minister. It is not his discretionary power because that.
But you're missing one point, that he said
That is
that
applicable for
concerning
Article
the sixth
356.
schedule, it is different.
356.
Governor
That is applicable
and
for Article
President.
356. Not
Yes,
under the 6th schedule.
356.
Yes, I can say, my lord, and some of the judgment I refer 356. That is the power of the president, the governor. But the judgment I relied upon,
The latest.
the one, no, not only the latest one, Jayanta Rongpi. Rongpi, very specifically 6th schedule. Because here it is very clear, 356, all in the judgment.
So you have mentioned. No,
I have mentioned, but just to counter submission of AG,
Yes,
that
Jayanta,
he submitted
which was
that the
conditional
power under
judgment.
356 and 6 schedules
The
are entirely
deputation and
different.
council.
But this judgment was passed by 2 judges. My lord, if you see this, the heading of this Jayanta, it was passed by UL Bhatt and RK Mishra Singh.
So where is the
Division
judgment? Have you given me a
I
copy
have
of
given
that?
to you Jayanta Rongpi.
Jayanta Rongbi.
Yeah,
So
1994.
you are rebutting the submissions made by the AG, saying that this is not correct because there is that judgment.
In
Okay,
this
leave it at
judgment
that.
clearly mentioned that in the middle of the judgment, what was that cited by Chief Justice Chandrachud, Bhagwade, all 356 was written, cited, and in the end, it was confined to 6th schedule. Then we cannot say that they are different, entirely different, since as long as DB of this Guwahati High Court referred that 356 judgment for setting aside of the impugn notification of the President's rule proclamation. That is my point. It is not
Okay,
different.
Fine. Oh, anything else? That's it?
That's my priority. That
If that's it, ma'am.
my last submission is that even
Okay.
in my petition also they have no specific denial that there is no provision on the grounds that political instability.
You have
I have finished. That is my last point.
you are repeating yourself over and over again. That point
That's
is
my
there.
very good point. My first point.
So very good point, but you don't have to keep repeating it.
Yeah, that's true, my lord. That is my last point.
So many repetitions.
Yeah, that's
We
true.
are taking a lot of time. Yes.
Yeah, that's
Heard
my last
Mr. J.C. Lalunsanga, Learned Counsel for the petitioner, along with Mr. B. Dave, Learned AG, Advocate General for the state respondents, and Ms.
H.C. Deborah.
Deborah, Learned Counsel for respondent number.
I am assisted by Ms.
6.
Mary Kyangte.
Yes, assisted by Ms. Mary Kyangte, Learned Government Advocate. And Ms. Deborah so-and-so, Learned Counsel for respondent number 4. A hearing concluded, matter reserved for judgment.